All right, good morning. We're here in case of State of Florida versus Curtis Reeves, case number 2014-0216, CFAES. The state is present and represented by Ms. Sumner, Mr. Garcia, and Mr. Lowry. The defense is present and represented by Mr. Michaels and Mr. Escobar, and Mr. Reeves is present, and he is dressed out in a tie and a white shirt. And let's see here. We're here for a pretrial. The defendant's now been held in custody without bond since January 13th of 2014 on the charge of second-degree murder and aggravated battery. And these charges are with firearms by the information filed on January 31st of this year. Because a firearm was alleged in the information under Chapter 775.087, that means that a conviction of these charges would result in a 25-year minimum mandatory sentence on the first count and a 20-year minimum mandatory sentence on the aggravated battery count. A bond hearing was held on February 5th and February 7th, 2014. Bond was denied, and I believe that decision has been under appeal with the Second District Court of Appeals since March or perhaps April. Mr. Escobar, I've been in court with my other cases this morning. I'm guessing you watched The Wire pretty quickly, or pretty currently. Have we gotten an answer from the Second DCA this morning?
Nothing from the Second District, Your Honor. We are patiently awaiting.
Well, Wednesdays and Fridays are generally the day that they grade my homework, so they will get me an answer, I'm sure, at some point. Let's see, the first pretrial was held early in March, only lasted about 13 minutes. We didn't really do very much. Both sides asked for a second pretrial, and the defendant waived his right to speedy trial at that time, and in fact waived his presence. The court accepted the waiver of presence and the waiver of speedy trial so that the two sides could prepare for trial. The court will now review what's been accomplished during the pretrial today in the 4 months that have been allotted. This now being the second pretrial, July 9th, 2014. We have a number of issues to cover, and we're going to try and proceed through them in an orderly manner. After the court's covered all of the issues it believes is necessary and important, we're going to hear from the state on any outstanding issues they think I should address, and we'll hear from the defense. Mr. Reeves, at the end of the entirety of the hearing, after we've addressed all the issues, I'm going to give you a chance to speak with your attorneys. If there's anything that you feel that hasn't been covered that needs to be covered so we can advance your case to trial, you can bring that to my attention either through them or directly. You don't have to say anything, of course, if you don't want to. I just like you to know that you have the opportunity to speak if you want. Let's see. Since it's my intention to set the case for trial, as I expressed 4 months ago, I want to hear how discovery is proceeding. I got a response from the defense yesterday. I've had a chance to look through it quickly, but first I had in the pretrial order indicated that I was going to want to hear from the state on it, so let's hear from the state first. State, have you provided all of the witnesses you intend to call at trial and witness list to the defense?
Yes, Your Honor.
Okay.
Now, Judge, there is still outstanding discovery. There are experts that are working on the case.
Well, that's my next question. My next question was going to be, is there any physical discovery in the form of written statements or expert reports that need to be discovered?
Judge, we, Mrs. Sumner and myself, have been diligent, and as soon as the reports are coming in, we are listing the witnesses and also providing reports to Mr. Escobar.
All right. How many more are we looking at getting at this point?
Well, we still have the expert that's reviewing the video. We have not heard from him as of yet, but I know he's working on it.
An expert reviewing the video, I'm not sure exactly what that means. Is this somebody that's attempting to enhance it in some way, or?
Well, exactly, Judge. Enhance it, obviously analyze the video, analyze, the flashes, so on and so forth that you see in the video.
Okay. What's our estimated time of arrival for that report?
To be honest with the court, Judge, I don't know.
Okay. Besides the video analysis, what else are we waiting for at the state?
Judge, that is pretty much it.
The defense made reference to some type of a GSR report from FDLE that might be coming. Is there a GSR being done on this one?
We've been discussing that with John Romeo from the Florida Department of Law Enforcement, and we're still working on that, Judge. There's some issues that we have to work through as far as the GSR, whether or not it can or cannot be done because of the path of the bullet.
Okay. And has the defense provided you any reciprocal witnesses that you need to depose still?
I do not have a reciprocal witness list, Judge. No, sir.
None. Okay. And so defense, obviously you have no obligation to present any evidence during the trial. However, have you provided the state a list of any witnesses you may choose to call during the trial?
No, Your Honor, but we have selected to date 2 experts that we anticipate at some point in time will list as witnesses. They are likewise working with the evidence and working with the facts and circumstances of the case. I had spoken to Mr. Garcia early on and indicated to him that we were awaiting all of the results from the government in order to start taking depositions, and that's exactly what we've done. I was under the impression last week when we spoke to Mr. Garcia that this GSR had been done or was very close to being completed. He had to check with the lab, I guess, to determine whether that had been done. I'm unaware of the fact that it hasn't even been started. But we'd like for that to be started as soon as possible because we have a ballistics expert that we'd like to use in order to have our own GSR test done. So those are, important factors in us proceeding with discovery. I think the court knows that it's extremely important for us to get to know all of their forensic evidence before we start taking depositions of all these crucial witnesses. They listed 100 witnesses as Category 8 witnesses in this particular case. We have current dates that I've given the court in my response to the pretrial conference order showing the dates that we have currently set for depositions. For the court's knowledge, they only give Mondays and Fridays as depo dates for private lawyers. I can tell the court, and I'm sure the court knows, Mondays is a very difficult day to set depositions because all sorts of things are happening with all of our other cases. Cases are being set for trial. They are set for trial. We don't know if it's actually going, whether it's not going. And so I think that we set a deposition schedule. This morning, my secretary tells me that we've gotten October as well now. Still Mondays and Fridays. But as the court can understand, it's going to take us a considerable period of time if we're going to be deposing 100 Category 8 witnesses in order to get through all those depositions. Hopefully we'll be able to do it, Your Honor, I think sometime in November, December.
Okay. Well, the GSR, before we move on to the other issues, the GSR, are you asking for GSR tests from the swabs that presumably they took from your client, or are you asking for GSR swabs for other persons to determine the radius of the gunpowder?
That's correct, Your Honor, because there was stippling in this particular case, and that's going to be very important to us, especially stippling, in the alleged victim's right hand. And so we're going to need to have them finish their particular test with that gun so that we can then have our experts do some tests that I think are going to be probative to our theory of defense.
Okay. Mr. Garcia, do you know if the 2 victims were swabbed for GSR test purposes, both the victim that's deceased and the young lady that was shot? Do you know if they were actually swabbed by the detectives so that there's a packet?
I don't know.
All right. My recollection is, and it's been years since I've dealt with it, but my recollection is that the Florida Department of Law Enforcement does not do GSR anymore. Is that still correct, or have they changed their policy?
Yes, Judge.
So you're having to make a special request to get the GSR done?
We're discussing it with Mr. Romeo, Judge. He is the supervisor over the firearms section. As the court is probably well aware of, the FBI has stopped doing GSR because of the unreliability of the test. And I know that the Florida Department of Law Enforcement has stopped doing GSR because of that. There's so many false positives and so many variables out there that they do not consider it a reliable test.
Okay. How long is it reasonable to give you time to make your determination on whether you want the swabs tested if they took it? Because if you're not going to do the tests and Mr. Escobar wants it tested on behalf of his client, I'm going to order you to turn it over to him so that he can tested under the rules and procedure for defendants doing tests. But I'm still going to give you first crack at it, but I'd like to give you a reasonable amount of time to make this decision and then get it done so we can move forward. What are we talking here, 15 days, or you need more time than that, Mr. Lowry?
That'd be fine, Judge. I think that's a decision that can be made probably in a matter of days.
Okay.
Put our mind to it and stuff. Obviously, we're just in a situation where if we don't do it because of a variety of reasons, we're going to have to respond to then saying we should have done it, so we may have to call a witness anyway to say the reason we don't do it, and we just got to work our way through that.
So it sounds like you might as well just get it done then, and...
Well, I don't know, because, if you recall the video, obviously Mr. Reeves pushes his hand out. So, GSR distances make it, just because someone is stippling doesn't mean how close they are to the person, it means how close they are to the gun. So there's a lot of other variables that make this test maybe one we won't do.
All right, I understand.
So
Let's make a decision, though.
Put our mind together and we'll make a decision. And I would suggest if you'll give us
15 days from
15
today.
days is fine. We don't have to come back in court. We can just let Mr. Escobar know, and then he can go forward if he needs to get that information or that evidence to do his own testing.
All right, so what we'll do is 15 days from today, Mr. Escobar, if you've not heard from them, that means they're not doing it. If you've heard from them, it means they are doing it. If you've heard from them, that'll slow things down. If you've not heard from them, send me an order. Follow the regular procedures that the FDLE and the Pasco County Sheriff's Office has for taking possession of evidence for purposes of testing under their rules. And I know I've gone through this before where defense attorneys have had it tested in the past. So you follow their rules. You send me an order that outlines all their rules. Make sure that you run it by Mr. Lowry or Mr. Garcia so that they sign off on it. If they can sign off on it, then I don't even need to have a hearing. If they can't sign off on it, we'll set you a quick hearing date so we can get this tested if that's what in fact needs to happen. All right, moving past the GSR, other than this GSR gunshot residue test, and you say you have potentially two expert witnesses that you might be listing?
Your Honor, we have two that we have selected to work with us in this case, but I can tell the court that depending upon the testimony of the pathologist, we may have our own pathologist. There may be a use of force expert that we're going to be listing as well. It all depends upon some of the depositions and what the witnesses are saying under oath.
And I saw in your response that you have now finally set these depots. When did you set these depots?
Judge, these depots were set, I think, in the last 3 or 4 weeks. I think they've been periodically. I think we had the first set of depots in July and August that we set, and then we set September. I believe September was set actually yesterday, and today they gave us October.
So, to date, in the 4 months since the last pretrial, not a single deposition has been taken?
No, Your Honor, not a single depot, but I can tell the court, as an officer of the court, that we've been extremely busy with our own investigation concerning all of the witnesses that the state has listed. And I think that come depot time, we're going to be prepared to properly question. Again, I think that one of the problems I think that I'm going to foresee here is the fact that we've only got 2 days to take depositions, Mondays and Fridays. These depositions, I believe, are going to be lengthy. I would like to get at least, another day, maybe 2 days, to be able to continue to expedite this process of depositions. Just because Mondays is a bad day, and I can anticipate, me being in trial on another matter, whether it goes, whether it doesn't go. It can't be 2 places at one time, and I think maybe, adding a Wednesday would help us tremendously.
Okay.
Judge, if I might, I'll try to see what I can do about maybe relieving that in that respect, okay?
Okay.
If we juggle some things around. So, and just as a question, since we're talking about that, would you be in a position to do like day-long depots, you think, sometime?
They all have been set for day-long depots.
Okay, all right, then I'll get with Mr. Escobar before we set this next group, and we'll see if we can give him some relief and some more dates.
Okay. Well,
Judge, there is one more piece of evidence that I'd like to discuss that I was under the impression we were going to get. We were supposed to get, it's my understanding, a report outlining the analysis of Mr. Olson's cell phone, the text analysis of Mr. Olson's cell phone. As the court knows, There's a lot of testimony here as to what Mr. Olson was doing immediately prior to this particular incident. Those issues are important to us. It's my understanding that they had someone that was looking at the phone in order to do that. We have not received that report. Whether he was texting, whether he was not texting, who he was texting, what was being said. Those are important issues because they've been a focus, of this case.
Okay. Do you have any idea when the either cell phone records or texting records might be forthcoming, Mr. Garcia?
I don't, Judge.
Okay. Y'all are welcome to talk about this when I'm not here. I mean, in the 4 months intervening, if y'all want to get together and have discovery meetings, you can do that.
We've had great communications.
Okay.
Mr. Garcia and I have been in great contact. We've talked about trial dates. We've talked about,
Yeah, Judge, I was going to say, and I don't mean to interrupt Mr. Escobar, it may seem like we haven't done anything, but behind the scenes, trust me, myself, Mr. Escobar, and Mr. Michaels have been talking about the case.
Okay.
Discovery, trial dates.
All right, I just, I didn't know whether this was a duck on a pond and your legs were moving below the surface and I just wasn't seeing it or not, but I just want to make sure that we're moving because...
we've had a good relationship, Your Honor.
Okay, all right. Well, I appreciate the good relationship, but I'm hoping the relationship's going to move us forward to trial then quickly if that's in fact what's necessary. At this point, when I would generally ask the state, if Mr. Reeves were to enter a plea of guilty or no contest, given that I have a 25-year minimum mandatory on count 1, are you in a position to do anything other than the 25-year minimum mandatory?
Not as we sit here today, Judge. I mean, if the defense wants to talk to us about something, we always have open ears, but we're not looking to plead the case out.
I didn't figure you were, but it's just in the 30 cases that I handled next door, that's the question I always ask before I set the case for trial, so I figured even though it seemed like the most obvious thing going on in this case that you're not going to be able to work it out, I might as well ask.
No, that's fine. I mean,
if I don't ask, no chance of getting a yes, right?
Our ears are open, but we're not, looking for that.
I understand. And you would be seeking the 25-year minimum mandatory if you were to enter a plea today, or would you be seeking more than that?
I don't know the answer to
You
that,
don't know?
Judge.
Okay.
I mean, I would want to talk to the victim's family and things of that nature as well. I mean, it's,
Okay.
Figured
I would check. Mr. Escobar, again, I'm probably guessing the answer is going to be the same over here. There's no way that you can work this case out with the 25-year minimum mandatory hanging out there. I've got to set this case for trial. There's no other direction for me to go, correct?
No, the defense position is that we're probably going to go to trial.
Okay.
I highly doubt that there's going to be any negotiations that are going to be acceptable. So
I understand. I figured I'd ask, though. Okay. So we figured out that we can't resolve it. We figured out we've got several issues still outstanding with discovery. So this is going to become an impediment to my plan that I had when I walked in here about setting the case for trial between October and December of this year. State, would you agree that it's impractical for me to get my October through December dream trial date to happen?
Yes, Judge.
Okay. Mr. Escobar, any way I can get this done?
no here.
Okay.
Judge, if I might too, I mean, just a couple comments. Mr. Escobar was saying, and no disrespect, he's waiting for all this information for it to do depots. Obviously, the 100 witnesses, we aren't going to call all those folks. Most of them have nothing to do with the expert testimony, and their depositions could be taken without waiting for GSR and that kind of thing. And that's for being set now. The real issue, I think, is setting by the end of the year is I fully believe Mr. Escobar will have a number of expert witnesses, and we really don't want them dropped in our last week before trial. Not saying he would do that. So we've had a good relationship, and so, there's, as you know, there's two parts of discovery. They get that, and then when they decide they want to give stuff to us, if they so decide, then we have to go through that process. So
I understand.
that's why I don't think it's really practical to do it in 2014.
Okay. Well, problem is that I don't know where I'm going to be in 2015. So I can't set you a trial in 2015 right now because I don't know until the chief judge tells me. That's not possible for me to know, and the chief judge isn't going to tell me until August 26th. So,
I can tell you from the defense, our position is that you've heard 2 days of hearings. We certainly would encourage the chief judge to keep you on this case. It makes no sense to bring someone brand new into this particular case. I mean that sincerely.
And here I thought we were friends. You want me to stay on this? I understand.
We would, Your Honor. We just think it's practical. And I
Okay.
think that the prosecution would probably feel the same way.
Okay. State, you want me to stay on this no matter what happens?
Sure, Judge, we would be happy to.
Fantastic.
Have you replaced.
Thank you.
That means you gotta make a drive or not, but,
I already make a drive to get here, so it's okay. The question becomes then, if I get reassigned, obviously, if I'm not reassigned within crime, I'm not keeping it. I appreciate it, but I'm not keeping it if I'm not reassigned within crime. If I am reassigned within crime, I'm either going to probably be here or I'm going to be over in Newport Richey. Does the state have strong feelings on whether you want me to keep it in this courthouse or you want me to take it over to Newport Richey if I go? Because I'm going to have to start bargaining now with Judge Sestag to get this courtroom for 2015 if that were to happen. I guess I don't necessarily need that answer today.
we'll think about it. Thank you, Judge. Yeah.
And Mr. Escobar, I'd want you to think about the same. I don't know if you have a preference between the two courthouses. If I get reassigned to crime on the other side of the county, I will have a courthouse over there, or a courtroom, but if I don't get crime, I guess it won't matter. You'd have to come over to Newport Richey probably. I don't see how I could practically do it here. All right, other issues to go through. Well, I had it on my list of things to resolve and bring to the attention of both sides, but I'm not sure I'm going to be able to get a firm commitment one way or another. Mr. Escobar, are you going to wait until you've gone through all the depositions before you make the decision on whether you're going to file a request for immunity under 776.032, or do you know that now?
No, Your Honor, we're going to wait till we've done the discovery.
All right. So if that happens, I am going to expect your motion on that at least 4 weeks before the trial, because my expectation is if I get and I know we're kind of talking in code there, but there are people watching. I hate to say the words because it tends to make people excited, but if there was a stand your ground motion under 776.032, I'd need it 4 weeks before the trial. If I didn't get it at least 4 weeks before the trial, because I'm going to probably have to set out at least 3 or 4 days in order to do that, I'm going to do it during the trial. In other words, I'd hear all the testimony and I'd make my decision during the trial. I know the state wouldn't be very excited about that proposition either, but I can't have you delay the trial by dropping that motion on me within 4 weeks. So I'll give you plenty of time. I know that you don't rush into things, so I'm sure you'll do it well in advance. When's the last deposition that you have set right now?
Your Honor, we got depots through October. One of the problems that we're going to encounter is that Mr. Michaels and myself have the FAMU alleged hazing case starting in September, mid-September. That's going to be probably a 2 to 3 week trial.
Yeah, I saw that. I read the papers on that.
And that's going to trial. There's really no room for any negotiations there. It's going to be going to trial. So,
Why did it continue the last time?
because some of the government witnesses were not available.
Okay.
So we still have just a few depots to take. We don't have many depots to take. There was over 100 witnesses in that case as well.
Okay.
So, and they were all throughout the state. So, we're going to have those issues, throughout at least the end of September.
All right. So let's say that we were to come back in October so that we could know where everybody's going to be, and if I'm not still in crime, I'll introduce you to the judge that'll be replacing me, and you can deal with them. But if we were to go to October for a pretrial, I could do October 15th. That would be in week 2 of a death penalty case that I have set. I could do October 15th at 10 a.m. or if the Wednesday's not good, I could do Tuesday, October 14th at 10 a.m. Mr. Lowry, do you have a preference one way or another?
I don't, Judge.
You drive the farthest to get here?
Yeah, but I think any of those days are fine.
We're fine.
Okay, so why don't we make it October 14th? We'll mix it up. We'll make it a Tuesday this time. So October 14th at 10 a.m. I'm going to set a pretrial. Let's go over the things we're going to work on besides getting the depositions and the discovery completed. Issues to be considering when we come back. Let's talk about countywide panels first. You'd be entitled to a countywide panel. Either side could ask for a countywide panel. If the case stays here in Dade City, the panel would be drawn from this side of 41, is my understanding. You have a much better chance of getting a panel if people aren't driving all the way from Hudson and Newport Richey. However, both sides are entitled to ask for a countywide panel. I want to know on October 14th whether you want a countywide panel or whether you're okay with a panel from whatever side of the county we're going to be handling it. If it winds up going to Newport Richey, you'd get a panel from Newport Richey. If it winds up staying here, you'd get a panel from this side. And if you want a countywide panel, that's fine, but both sides, I think, are aware of the difficulties with people traveling as far as they'd have to travel in a land expansive county like this. So that's one issue I want you all to consider. Jury questionnaire. I'm not sure that we need to get it done by then, but I want you to start thinking about it by then. I'm going to require that both sides provide me with their requests for the questionnaire 3 weeks before the trial. I'm going to set a status check 3 weeks before the trial, so this is just things that I want you to have in mind and start thinking through. These are things I've been thinking through, and I have standard questionnaires that I use in homicides or cases that have been in the media. I don't think I've had a case that's been in the media like this before, however, so the questionnaire is going to be much more detailed. I'm going to be meeting with some of the other judges that have handled media-intensive cases like this at Circuit Judges Conference in a couple of weeks, and I'm going to talk to them about the questionnaires they've used and see what kind of positive or negative results they've had. If the two sides can come up with a questionnaire together, that would be fantastic. I would be probably 100% okay with that. If y'all can't come up with one, though, we're going to have a short hearing on it, and then I'm going to give you what I think is going to work the best so that we can make jury selection work as efficiently as possible. Sequestration. I'm going to need to hear from you whether you're going to want a sequestered jury through the entirety of it or if you just want that jury sequestered effective post-closing argument. If you want sequestration effective time of swearing, well, that's a huge undertaking for the court and the county as a whole. I'm going to have the sheriff allocate a tremendous amount of resources. I'm going to have the clerk's office allocate a tremendous amount of resources. I have already looked at the sample sequestration orders that are provided, the models, and I've gone through some of the things that would be necessary. Because it's going to be such an undertaking, I want both sides to start thinking now whether that's something they're going to request or not. It'd be a panel of 6, is my understanding, which means that I'd have to select probably 3 alternates given how much time it's going to take. Since we're on sequestration, if you request sequestration, I'm putting you on notice now, I'm going to be expecting that we work on Saturdays. There's no way that I'm going to take people out of their lives for 3 weeks for this trial without working on Saturdays. If they're away from their families, I want to shorten it as much as possible. I'm willing to work on Sundays. I'll give either side a heckler's veto on that. If you don't want to work on Sundays, I'm not going to make you. However, it seems it'd be in everybody's interest to get it done. And when I say work on Sundays, I'd arrange for the jurors to attend services if they wanted on Sunday mornings, and then we would work Sunday afternoons. Even if it's just us getting together as attorneys, judge, clerk, and other staff to advance the trial, my expectation is that if we're taking people out of their homes, we're returning them to their homes as quickly as possible. So I want you all to think about whether you want sequestration through the entirety of it, or if you just want sequestration from the verdict, or from the end of closing arguments. Let's see. Media scrutiny. It's obvious that this has drawn a lot of media, and to that end, I'm going to want both sides to weigh in when we come back in October on what their expectations are for jury selection. Obviously, the case is going to be open to the public and open to the media all throughout the trial, and I pretty much have a record of expecting that media attention and participation be facilitated. However, jury selection being perhaps the most boring portion of a trial ever, if they want to be present, we're going to discuss what rules they're going to be present under. That includes cameras. Now, many of you followed the Dunn decision that came out of the First District Court of Appeals recently that dealt with media presence during jury selection and how it was done in that case. The Dunn decision really spells out a lot of what's necessary. It's going to be my intention in October, after I get y'all's answer on what you're expecting for jury selection, to meet with the media representatives that want to be present after that pretrial, when I in fact set the trial date, to discuss with the media what they would be looking for in the way of their participation during jury selection, and to discuss with them what my expectations were and what my order is going to be on how they're going to participate. I'm going to have them have the opportunity, if we can't all come to an agreement, to have a hearing where they can intervene and file briefs if they wish, because the Dunn decision basically says I'm supposed to do that, if they don't like the framework I set up for their jury selection venue. If we're still in this courthouse, and I'm still here and the judge involved, I'd be using this courtroom for jury selection. You see how big this courtroom is, so you understand. I don't know if either side is going to use a jury consultant. I don't know how many attorneys are going to be present for either side. I have a limited jury box over there, which means that state, if you talk to the victim's representative, they have the right to be here, I believe, for a portion of the jury selection as well. And it's my understanding the current state of the law, and I try and read it and keep up to date with it, but I understand the current state of the law is that the defendant is allowed to have friends and family present for jury selection as well. My expectation in this case is jury selection is probably going to last for about 3 days if we move efficiently and effectively. And that's based on doing death penalty cases here. Mr. Garcia, you've done some high-profile cases here before. Do you have any reason to believe that we'd have to go any longer than 3 days in jury selection?
Judge, because of the media attention that this case has gotten here as well as internationally, it may go into 4 days, Judge. It's hard to, definitely probably 3, we may go into 4.
I'm thinking the first day is mostly going to be assessment of the panel questionnaires, and then the second day we're going to get to talk to people, and the third day hopefully we're going to get to decide on people. So that's kind of my plan with this. Mr. Escobar, your input, how many days do you think?
Judge, I'm really concerned about 3 or 4 days because of the media attention that this case has gotten. I don't think it's going to be an easy selection process, to be candid with the court. I'm hoping that it is, but a lot of the publicity has not been favorable publicity, and it has been not only in the state of Florida, but throughout the country as far as South America. So I'm concerned about that, and I think that we're probably going to need more than 3 days in order to select a jury.
All right. Well, when we do the planning and scheduling for the trial, my optimistic and sunny view of the world tells me that we're going to try and shoot for 3 days, with the understanding that on the 4th day, my expectation is we'll roll into opening statements and witnesses. So let's say that my hopes and dreams come to pass and we're able to select a jury in 3 days, and then on the 4th day, the state were to begin their case. If on that 4th day the state were to begin their case, one of the questions I asked in my pretrial order is, how many days do you anticipate, and I know this is just an estimation, but how many days do you anticipate we would need in order to try this case, Mr. Garcia?
Judge, Mr. Lowry and myself discussed that issue. We think conservatively 6 days it would take for the state to present their case.
All right.
For our case.
So let's say that we worked on a Saturday and we started on a Thursday. Let's say that we didn't use Sunday, hypothetically. We'd probably be rolling into the Wednesday following the beginning of jury selection, when we could anticipate the state would be wrapping up their case and the defense would be beginning, if they chose to put on a case, their case. Yes. That's a fair assessment?
Yes.
All right. Mr. Escobar, of course, Mr. Reeves has no obligation to present any witnesses, and the court does not wish to say anything that would in any way imply that he does. However, that being said, if he were to choose to do so, how many days would you anticipate you might need? And again, I'm not going to hold you to it. It's more just for me to help try and plan and figure out how we're going to make this work. How many days might you anticipate?
Your Honor, at this early stage, probably 5.
Okay. All right. And I would say that those are both pretty fair assessments. That's what I had kind of guessed. So thank you for that. All right. Within those 10 to 14 days, we might spend time taking testimony and analyzing evidence. Within those 10 to 14 days, one of the things that I suspect may become an issue is the possibility of needing to take the jury to the scene of the alleged offense. State, is it a fair assessment that that may be asked for either by you or the defense? Yeah?
Yeah, I mean, we don't have a.
Don't have a position yet?
I think it's a fair assessment.
Okay.
From one of the two, yes.
And Mr. Escobar, is that something I should expect?
Yeah, I would agree, Your Honor. I think you probably will expect that.
All right. And one of the things that I sat down and thought about before we got here today is how might such a thing be accomplished if it were asked for? And then I realized it's not all on me. Why, let's spread the wealth and the work and have the state and the defense come up with their potential plans. The Supreme Court has some standard jury instructions on this and some standard instructions to use, but if there are going to be any special instructions, I want you to start thinking about it now. Additionally, other factors to consider are, it's not our property. It belongs to the movie theater. I don't want to be going there in the afternoon. I'd want to plan to do this in the morning if it were to come up, and I would want in advance anything and everything that was expected of both sides to be set in motion and prepared for long before we get to that point. When we do this trial, I want it to go as smoothly as possible, and the only way that it can go as smoothly and efficiently as possible is if everybody thinks out what their position is going to be well in advance. So, if there were to be a jury viewing, I would like the state and the defense to start thinking about what their expectations would be now, and you're not going to have to give me that plan in October when we come back, but I want you to start to formulate it and take it into your consideration if we set the trial date, because I would expect the day that we go to the theater to be obviously not a weekend and obviously be early in the morning on a kind of a Monday, okay? Let's see, what else do we need to anticipate? I think we've gone through everything that I have to try and advance the case this morning. State, is there anything that we've not covered that you need me to cover today that could help advance the case so that when we come back in October, we're able to, in fact, set this for a trial date?
No, Your Honor.
Yeah? Okay. Mr. Escobar, is there anything that you would want me to cover that I've not yet covered that could help advance this case for trial?
You know, the only issue that I would like to maybe address is that if we're all in agreement that we're going to be trying this case sometime, you know, next year, I've got to give my experts ample time.
Okay.
In order to make sure that they're going to have those dates available. And so I think maybe in October, when we come back, we're going to be setting a trial date, most probably.
That is definitely on my list of things to do on that pretrial is, in fact, set that trial date.
We're doing that, but I've been talking to my experts, letting them know it's probably going to be at the very first part of 2015.
Okay. Well, if we waited till October to set the trial date, then I cannot make any promises because trials are being set. Not quite that far out yet, but trials are being set. If you want me to pick a trial date sooner than that, again, we could do it as soon as I get my assignment for next year to make sure that I am available to you, since y'all want to keep me. Why don't we look at a pretrial purely for the purposes of scheduling and or setting the trial a little bit earlier? We'll still keep the pretrial in October so that we'll have it after the depositions and other discovery is completed or very close to completed. We could do August, let's make it September.
We could have something, Your Honor, before the 22nd, because that is when we start our trial.
The band trial? Well, how about I could do September 10th? And that way we could get very early in 2015?
That would be good, Your Honor, and since we've filed a waiver of our client's presence at that pretrial conference. Can we do so for that date?
I can do that, since it'd be for the limited purpose of setting the trial, with the understanding that I'll have a conversation with him about him waiving his presence at the time that I set the trial. Is I'm not in the habit of setting a trial without the defendant present, but if that's something you'd be interested in me doing, I'll do that today before we leave. All right, so September 10th at 10 a.m., we're going to have a pretrial specifically for the purpose of coordinating calendars and picking a trial date at the beginning of 2015. I'll have my assignment at that time. You'll have at least a feeling for how the discovery is proceeding, and we'll know optimistically if January is the possibility or if I in fact need to look at February. All right. Reeves. All right. Mr. Reeves, because you're in custody, I obviously can't give you any privacy here in the courtroom to speak with your attorneys. If you would like, I can have the deputies take you in the back so that you can speak with your attorneys in private. If you feel like you've already got everything covered and you don't have any questions, I won't make them do that. I'm just giving you the opportunity to speak to them privately. I can't really do that. You're obviously in court. Do you need any additional time to talk to them, or are you ready to talk to me now? You're okay? Okay. Mr. Reeves, because I'm holding you in custody, no bond, it's of course my intention to move your case along as quickly and efficiently as possible. I had hoped to set a trial today. Obviously that, after reviewing the situation, is not a possibility. After having spoke to the attorneys involved in the case, I'm confident now that they're at least moving quickly. You know, I'm not told or given any information except at these hearings, so this is the only way I can find these things out. It seems like we've made some progress today in outlining the issues, and that we are going to be able to get an early trial date for you in 2015. Do you have any questions or concerns or issues that I can address for you before we break today? I know it's a wide spectrum of things, but I like to make each defendant feel comfortable communicating with me. You're well represented, of course, and I know they'd bring anything to my attention, but I always feel it's appropriate to extend to each defendant the courtesy of an open dialogue with the court if there's anything you in fact are concerned about that I can address. Okay. All right. Well, then if there's nothing else we can do to advance the case today, we'll be in recess. Actually, victim's representative is present, and Mr. Garcia, I am comfortable and confident that you'll bring to the court's attention if they wanted to speak or be heard, but I figured that I would ask so that you could check just in case. All right.
They're fine.
We're okay. All right. Well, that being said, then we'll be in recess until the September pretrial date.
Hey, guys.